Hello. This morning I'd like to talk about a decision just handed down by the full court of the Tasmanian Supreme Court. It's a very interesting case of Calvert and Badenoch, and well worth a read, I think. It discusses the duty of care that a solicitor owes when preparing a will. The facts were reasonably simple. The will maker wanted to leave the whole of his estate to a stranger, happened to be the son of his partner, and had no provision for his daughter. The other fact of relevance was that with this stranger, he held two properties which constituted the bulk of his estate, where he held those properties as tenants in common with the stranger. The daughter brought a family provision claim and was successful. The stranger then brought a claim of negligence, saying that what should have happened was to protect or ensure the testamentary wishes that the will maker had, that those tenancies in common should have been converted to joint tenancies, and they could not have formed part of a estate available for a family provision claim. Now, the case goes to look at what the duty of care was, and did it extend to giving advice about a family provision claim, and also, following on from that, what might have been done to minimise the risk of the claim or to in fact defeat the claim. One of the interesting statements that was made in the case that I just mentioned was a quote from another case, but it was quoted with approval, and it says this: "The precise scope of that duty will depend inter alia upon the extent to which the client appears to need advice. An inexperienced client will need and be entitled to expect a solicitor to take a much broader view of the scope of his retainer and his duties than will be the case with an experienced client." In the event, it's quite clear that the court expected that advice about the family provision claim would be given. There was acceptance that that had not occurred, and therefore the client, the testator, and also in turn therefore the stranger, did not enjoy the opportunity to be able to discuss how he might have gone, the will maker that is, in determining what should happen and what he would like to do. Have a look at the case. I think it does expand significantly, potentially, how far the retainer goes. It's simply, if you're told to make a will in favour of a sole person, that's not enough. You've got to take the issues further. So enjoy the read. It's a very interesting case.